All right, it's December the 13th, the year 2016. I did receive a 9x12 manila envelope from Edward Brown in my P.O. box today. It has no postmark on it whatsoever. And it has two sections. One section is 4 or 5 pages entitled History. The United States exists in two forms. And then the second section appears to be a court case that Ed Brown has pending in the First Circuit Court of Appeals. And let me just read the second section, which I will not read the whole thing because it's a long, it's several pages of like court documents. I won't read that now. It says, "Dear Rudy, please find enclosed a court case I have pending in the First Circuit Court of Appeals. Related a case pending appeal. File folder should be titled Ed Brown's Appeal to First Circuit. I'm starting to send you a plethora of how we lost our republic to a judicial mafia. Thank you, Sovereign Edward Lewis Brown." Okay, so I want to get back to the first thing in the document, or in the letter that he sent, and it's called History. The United States exists in two forms. So I'm just going to read that into YouTube. And if we ever have anybody volunteer to receive all this stuff and scan it into a PDF file, please reach out to me and let me know. All right, here goes. Number 1, the original United States that was in operation until 1860, a collection of sovereign republics in the Union. Under the original Constitution, the states controlled the federal government. The federal government did not control the states and had very little authority. Number 2, the original United States has been usurped by a separate and different United States, formed in 1871, which only controls the District of Columbia and its territories, and which is actually a corporation, the United States Corporation, that acts as our current government. The United States Corporation operates under corporate/commercial/public law rather than common/private law. The original Constitution was never removed. It has simply been dormant since 1871. It is still intact to this day. This fact was made clear by Supreme Court Justice Marshall Harla, Downs versus Bidwell, 182 U.S. 244, 1901, by giving the following dissenting opinion. Two national governments exist. One to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. The Restore America plan reclaimed the de jure institutions of government of the 50 state republics in order to restore the common law that represents the voice of the people and ends corporate law that ignores the voice of the people while operating under maritime admiralty international law. This occurred when warrants were delivered to all 50 governors on March 30th, 2010. The rewritten Constitution of the United States Corporation bypasses the original Constitution for the United States of America, which explains why our congressmen and senators don't abide by it. And the president can write executive orders to do whatever he or she wants. They are following corporate laws that completely strip sovereigns of their God-given unalienable rights. Corporate, commercial, public law is not sovereign private, as it is an agreement between two or more parties under contract. Common law, which sovereigns operate under, is not commercial law. It is personal and private. To understand this document, you need to understand some basic terms. Visit www.usaversusus.info for complete understanding. The basic terms are de jure, existing by right or according to law; original, lawful. Common law operates under de jure terms. De facto, in practice but not necessarily ordained by law. In fact, in reality. Corporate law operates under de facto terms. Note, all caps, titles, and names are legal fictions and fraud, including all court or government documents. Sovereign, a real person. Sovereigns can own property while citizens/subjects cannot. According to the original Constitution, all government comes from the sovereign individual. Without the sovereign individual, there is no government. U.S. citizen/subject. A corporate fictitious entity that merely represents the real person. It acts as a straw man. To call oneself a sovereign citizen or a sovereign subject is an oxymoron, since sovereign and citizen/subject are mutually exclusive of each other. When asked if you are a U.S. citizen on corporate legal documents, if you check yes, you agree to the terms of corporate law and unknowingly relinquish your page 14. Sovereign status and transfer all your rights to the United States corporation since you are now under contract. Corporation, a non-human fictitious entity. Corporate fictitious entities are denoted in all caps. This includes the names of citizens/subjects. Your fictitious straw man entity is addressed in all caps, i.e. John Smith, rather than John Smith spelled capital J, capital S only. Common law. God's law. Common law and the system of de jure juries apply to sovereigns in disputes. In common law, contracts must be entered knowingly, voluntarily, and intentionally. Admiralty, maritime law, international law. The King's Law deals with criminal acts that only apply to international contracts. Under this law, the people are no longer sovereign. The Uniform Commercial Code, UCC, and the United States practices is based on admiralty law. Under the UCC, contracts do not have to be entered into knowingly. Simple agreements can be binding, and as long as you exercise the benefits of that agreement, you must meet the obligations associated with those benefits. If you accept the benefit offered by the government, then you must follow to the letter each and every statute involved with that benefit. That benefit is the Federal Reserve notes, U.S. dollars. By paying for things with U.S. dollars, you are unknowingly giving up all your constitutional rights and are legally obligated to follow all the UCC statutes. But you were never told this. Lawful, a term used in common law. Legal, a term used in the UCC which applies to corporate law. How the Constitution was usurped by the corporation. Note by Panama Legal. These are the basic premises adhered to by the people in the movement and the people in the sovereign movement. The government is a corporation actually functioning as the federal government. Thus, it does not have to follow the Constitution. Also, it does not matter if Obama is not a natural-born citizen, since it is a corporation he is the head of. The corporation gets the permission. The corporation gets the permission of the people to reign over them by deceit. This is done by wording in the birth certificate, social security cards, driver's license, IRS forms, marriage licenses, and other documents. They always refer to the person in all capital letters. This means the name represents a corporate entity. This is how the corporation courts get jurisdiction over you. Their courts do not fly the real American flag. They use the military or admiralty flag. For a discourse on this, try the website www.usavsus.info. What the theory is goes like this. When you enter a U.S. courtroom, there is a military or admiralty flag flying. The U.S. military. There is a military or admiralty flag flying. The U.S. military does have the protection of the Constitution. Let me read that again. The U.S. military does not have the protection of the Constitution. Neither does this apply to admiralty laws with ships at sea. When you enter a courtroom and cross through that little wooden gate they have and go to the area where the plaintiff, prosecutor, and defendant sit along with the judge, court reporter, you are entering a ship of a foreign country, as evidenced by the admiralty or military flag flying. Thus, the Constitution has no applicability, and you are under equity law, not common law. The flaw with their scheme is that there is no full disclosure to the people about any of this. This is a brief, oversimplified synopsis of the scam ran by the federal corporation. End of our comment. In 1788, the United States was officially bankrupt. In 1790, August 4th, let me read that again. In 1788, January 1st, the United States was officially bankrupt. In 1790, August 4th, Article 1 of the United States Statutes at Large, pages 138 through 178, abolished the states of the Republic and created federal districts. In the same year, the former states of the Republic recognized as, page 15, recognized as corporations and their legislatures wrote new constitutions absent defined boundaries, which they presented to the people of each state for a vote. The new state constitutions fraudulently made the people citizens, capital C, of the new corporate states. A citizen, capital C, is also defined as a corporate fiction. In 1845, Congress passed legislation that would ultimately allow common law to be usurped by admiralty law. www.barefootsworld.net/admiralty.html explains this change. The yellow fringe placed at the bottom of the court flag shows this to be true. Before 1845, Americans were considered sovereign individuals who governed themselves under common law. 1860. In 1860, Congress was adjourned sine die. Lincoln could not legally reconvene Congress. In 1861, President Lincoln declared a national emergency and martial law which gave the president unprecedented powers and removed it from the other branches. This has never been reversed. In 1863, the Lieber Code was established, taking away your property and your rights. From 1864 to 1867, several Reconstruction Acts were passed, forcing the states to ratify the 14th Amendment, which made everyone slaves. In 1865, the capital was moved to Washington, D.C., a separate country, not a part of the United States of America. In 1871, the United States became a corporation with a new constitution and a new corporate government, and the original constitutional government was vacated to become dormant, but it was never terminated. The new Constitution had to be ratified by the people according to the original Constitution, but it never was. The whole process occurred behind closed doors. The people are the source of financing. The people are the source of financing for this new government. In 1917, the Trading with the Enemy Act, TWEA, was passed. This insightful video from link to movielocker.com/4084 states the following. This act was implemented to deal with the countries who we were at war with during World War I. It gave the president and the alien property custodian the right to seize the assets of the people included in this act, and if they wanted to do business in this country, they could apply for a license to do so. By 1921, the Federal Reserve Bank, the trustee for the alien property custodian, held over $700 million in trust. Understand that this trust was based on our assets, not theirs. In 1933, 48 Stat 1 of the TWEA was amended to include the United States person because they wanted to take our gold away. Executive Order 6102 was created to make it illegal for a United States citizen to own gold. In order for the government to take our gold away and violate our constitutional rights, we were reclassified as enemy combatants. In 1933, there was a second United States bankruptcy. In the first bankruptcy, the United States collateralized all public lands. In the 1933 bankruptcy, the United States government collateralized the private lands of the people, a lien. They borrowed money against our private lands. They were then mortgaged. That is why we pay property taxes. From a speech in Congress in the bankruptcy of the United States Congressional Record, March 17, 1993, Volume 33, page H-1303, Speaker Representative James Traficant Jr., Ohio, addressing the House states, quote, "It is an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89 through 719, declared by President Roosevelt, being bankrupt," page 16, "and insolvent," HJR 192, 73rd Congress, M. Session, June 5, 1933. Joint resolution to suspend the gold standard and abrogate The Gold Clause dissolved the sovereign authority of the United States and official capacities of all United States government officers, and departments, and is further evidence that the United States federal government exists today in name only. The receivers of the United States bankruptcy are the international bankers via the United Nations, the World Bank, and the International Monetary Fund. All United States offices, officials, and departments are now operating within a de facto status in name only under emergency war powers. With the constitutional Republican form of government now dissolved, the receivers of the bankruptcy have adopted a new form of government for the United States. This new form of government is known as a democracy. Being an established socialist communist order under a new governor for America, this act was instituted and established by transferring and or placing the office of the Secretary of Treasury to that of the Governor of the International Monetary Fund. Public Law 94-564, page 8, section HR 13955 reads in part, "The United States Secretary of Treasury receives no compensation for representing the United States." Prior to 1913, most Americans owned clear allodial title to property, free and clear of any liens or of mortgages until the Federal Reserve Act of 1913 hypothecated all property within the federal United States to the Board of Governors of the Federal Reserve, in which the trustees, stockholders, held legal title. The United States citizen, tenant, franchisee was registered as a beneficiary of the trust via his or her birth certificate. In 1933, the federal United States hypothecated all of the present and future properties, assets, and labor of their subjects. The 14th Amendment, United States citizen, to the Federal Reserve System. In return, the Federal Reserve System agreed to extend the Federal United States Corporation all of the credit, money substitute it needed. Like any debtor, the federal United States government had to assign collateral and security to their creditors as a condition of the loan. Since the federal United States didn't have any assets, they assigned the private property of their economic slaves, the United States citizens, as collateral against the federal debt. They also pledged the unincorporated federal territories, national parks, forests, birth certificates, and nonprofit organizations as collateral against the federal debt. All has already been transferred as payment to the international bankers. Unwittingly, America has returned to its pre-American Revolution feudal roots, whereby all land is held by a sovereign, and the common people had no rights to hold a allodial title to property. Once again, we the people are the tenants and sharecroppers, renting our property from a sovereign in the guise of the Federal Reserve Bank. We the people have exchanged one master for another. End quote. In 1944, Washington, D.C. was deemed to the International Monetary Fund by the Bretton Woods Agreement. The IMF is made up of wealthy people that own most of the banking industries of the world. It is an organized group of bankers that have taken control of most governments of the world, so the bankers run the world. So the bankers run the world. Congress, the IRS, and the President work for the IMF. The IRS is not a United States government agency. It is an agency of the IMF, Diversified Metal Products versus IRS et al., CV-93-405E-EJE, USD, CDI, Public Law 94-564, Senate Report 94-1148, page 5967, Reorganization Plan number 26, Public Law 102-391. How can we repair our country right now? The Supreme Court has said the de jure government offices still exist, but the people have failed to occupy them. Remember Downs versus Bidwell and the dissenting opinion of Justice Marshall Harlan? He said that two national governments exist, one to be maintained under the Constitution with all its restrictions. That is one that we, the people, need to force our elected officials to occupy. De jure rule. We need to change that by organizing grand juries and putting our officials back under de jure rule and out of the corporate or military rule that they currently that they are currently operating under. Our elected officials will then have to operate under the limits of their oath of office to uphold the U.S. and state constitutions, circa 1860. When they violate the oath, it's a capital crime. The reason we go back to 1860 is because that is the last time we had lawful laws in this country. Where do the people get their power to convene a grand jury? The Magna Carta 1215. Our founding fathers looked back to history for precedent when they decided they wanted to change their government. When they found what they found was the Magna Carta Liberatum, the Great Charter of Freedoms. It set a precedent that changed the face of England forever by establishing that the king was not above the law. King John of England signed the Magna Carta after immense pressure from the church and his barons, the people. The king often lived above the law, violating both feudal and common law, and was heavily criticized for his foreign policy and actions in England. The barons, with the support of the church, pressured King John to spell out a list of their rights and guarantee that those rights would be enforced. The barons provided a draft. After some negotiation, King John put his seal to the Magna Carta in Runnymede in June of 1215. Section 61 sets rules for establishing the grand jury. It states, "Since we have granted all these things for God, for the better ordering of our kingdom, and to allay the discord that has arisen between us and our barons, people, and since we desire that they shall be enjoyed to their entirety with lasting strength forever, we give and grant to the barons of the following security. The barons shall elect 25 of their number to keep and cause to be observed with all their might the peace and liberties granted and confirmed to them by this charter. If we, our Chief Justice, our officials, or any of our servants offend in any respect against any man, or transgress any of the articles of the peace or of this security, and the offense is made known to four of the said 25 barons, they shall come to us." Official site of the Republic for the United States of America. All right, that's the end of page 17. That was all that Edward Brown sent to me for this particular stapled document. It's called The United States in Two Forms, History. All right, God bless.